Hey, Janitra, how are you? I see there's 14 people in the chat. Only one person is speaking. You know what, Janitra? I'm gonna send you a link, and I'll show you what I'm trying to show because no one else is trying to speak in here. So I'm gonna send you the link. Okay. I'm gonna end this live, and I'll. Hey, Vicky. AD. I'm sleepy. I came on because I said I was gonna do it early and I had gotten caught up. But since it's only 3 of you guys in here speaking, I can give you guys the link and we can go behind the Janata's in here as well. I was gonna just give you guys the link and then we can go look at behind the scene. Okay, the Toya is coming in. So I got 1, 2, 3, 4, 5. Oh no, 1, 2, 3, 4. 4 individuals speaking. All right, guys. Latoya, AD, Trinata. Okay, here come other people. Hey, Shelly. Okay, you guys are coming in here. I was about just to give them the link, and we were going to look at this footage behind the scene. If I didn't have enough folks coming in here, I was just going to do it behind the scene. Yeah, I think I will. Yeah, I think I'll do that. All right, Classy Coco, Shelly, Marquita, Toya, AD, Denitra, Vicky. All right, guys, there goes Spitting Fire. Spitting Fire, hey. If you're tired, go to rest. No, I'm not that tired. I just I want to keep my word. Hey, Spitting Fire. I'm gonna get my my what's the name so I can yeah, I'm just gonna play the Rule 22 meeting part and then I'm gonna end it. I'm gonna end it after I finish the Rule 22 meeting, okay? It's not that long. So you can understand what the judge was saying. Let me put my overlay on here. Hold on a second. And put my overlay. All right, there go my overlay here. I'm gonna put that in there for my for the meeting. I got a notification. All right, guys, let me go ahead on and start this up. This is from the Rule 22 meeting today that we had at court. Let me just show it to you guys. Let me play it for a second.
Chair Vice President.
Okay, here we go. Let me put it in here. Hey, Koopy. All right, let's do this. Okay, there we go. I put my thing on there strong today. You see it's strong, right? I ain't playing with them today. I ain't playing. And people be like, oh, why you put the thing on? We can't see. There's a reason why. Oh, feel better, AD. All right, guys, here we go.
Is everybody back? Otherwise accounted for? Don't have accounted for, otherwise is Mr. Johnson. Ms. Fagan, good to see you. All right, well, you were accounted for earlier, madam. I'm just teasing you. Okay,
You don't hear no audio?
Okay. All right, so Ms. Bernard, you don't mind standing in for Mr. Johnson? All right, let me find out. Mr. Evans, you okay with that?
They weren't saying anything earlier,
fine,
Shelley. They wasn't saying anything. That's why you didn't hear anything.
Okay, folks, let me go ahead and take up something right quick since we have representatives from the media here today. I filed on the 3rd of February a Rule 22 to address certain issues I'd like to do without the media's presence. But in order to satisfy Rule 22, this particular notice was sent, and I'll include it as the next court exhibit, to the media outlets. I believe we have at least one media, and it's, sir, come on up. He would, I know who you are, but just identify yourself first, the record, and who you represent, sir.
Happy to do that. Your Honor, you prefer that I argue with my mask on or with it removed?
Sure, you can. We can hear you. That's fine. Okay. So if you'll just speak into the microphone, we should be able to hear you.
Very good. Your Honor, my name is Tom Clyde, and I'm here on behalf of the Atlanta Journal-Constitution, WSB-TV, CNN, and the Associated Press.
All right, sir. Let me just kind of tell you the basis for what we're asking for at this point in time, and this would just be for a minimal excusal for about maybe 20 minutes for me to go over some things with the lawyers in reference to some 5th and 6th Amendment rights of other clients. So I don't want to exclude you for any length of period of time other than that, but this would just be for me to cover some issues that would go to the ability to have a fair trial. So, and that's the basis for the closure for that particular period of time.
So, Your Honor, I'm going to react to that in the best way that I can.
Sure.
And so, first of all, let me say we very much respect the attention that the court has consistently given to media access issues throughout this case to this point, and we fully anticipate that to continue in the future. With respect to excluding the media from the courtroom for certain proceedings, that is a very significant step. It's a step that is a step beyond Rule 22. Rule 22 speaks to the photographic access to the courtroom, and the Georgia Supreme Court, as a matter of policy, has passed Rule 22, expressing its view that it favors photographic access to the courtroom, but provides Your Honor, and every judge the ability to make certain decisions about that under the standards articulated in Rule 22. Excluding the media from the courtroom would actually be a different step and a much more substantial standard. It would essentially, that step, excluding the media from the courtroom, is essentially a First Amendment issue. And the Supreme Court addressed that in a case called Page versus Lumpkin, where it articulated the view that not only is that protected by the First Amendment, not only is public trials protected by the First Amendment, but our state constitution point blankly states that trials shall be public, and that creates both a Sixth Amendment right for the individual defendants, but a First Amendment right for the public to observe the trials. That being said, Your Honor, we also acknowledge, obviously this isn't a death penalty case, but I will give you as an example in a death penalty case, there are certain moments where the judge has to speak to the defendant to make sure the defendant is satisfied with the performance of their own counsel. Those are traditionally done in a closed environment. So it's conceivable to me, Your Honor, that what you could be requesting is appropriate, but at this point, I have to, on behalf of my clients, object to the closure of the courtroom. The way this process is supposed to work, and I understand the court is trying to keep it ahead of issues, is the defendants under the Page versus Lumpkin case are required to bring a written motion. And the Lumpkin is very clear that it has to be a written motion, and then the court considers the request by the defendants in that written motion, but that written motion gets docketed and the media then respond to the written motion. And it's possible the undertaking that the court is considering will not trigger an objection from us. But I don't comfortably have a sufficient information to be able to waive the First Amendment right to access to the courtroom on behalf of my clients. So we do object to the closure.
Certainly, and this is part of the procedure, and I can tell you, it solely relates to the some issues that I need to take up with them that affect their Fifth and Sixth Amendment rights to a trial. So, and since there's a double-edged sword about the media, we want everyone. It's assumed that the public has a right, and it shows fair trial, just trial, lawful trial, and that the proceedings are for educational or other purposes. Then the flip side of that is, unfortunately, because of everything we've covered this case from tip to tail, basically thus far, everybody knows everything about potentially what's going on in this particular case, which in that respect, since we have not otherwise seated the jury, poses some challenges. So that is why the limited aspect or my ask in terms of the 15, 20 minutes, so I can cover some things and put them on the record. But I won't otherwise. If they did, would affect the defendant's Fifth and Sixth Amendment rights, particularly their Sixth Amendment right to a fair trial. So that's why I'm asking, or that's why I noticed you.
And we appreciate the notice, and Your Honor, I'm just not in a position to.
Sure, yeah, I wouldn't expect you to waive it anyways, right. But I just had to, as somebody who understands the media's right in a free society, I certainly wanted to follow the dictates of Rule 22.
I understand, Your Honor, and again, we appreciate the attention the court's given this issue. I do think Page versus Lumpkin would be worthwhile just to take a look at in connection with this issue, and I can give the court the site if that's helpful. 249 Georgia 576.
576?
Yeah.
All right. Just give me a minute.
Sure.
We researched the issue a little bit, as you can imagine. Mr. Clyde, we researched the issue a little bit. Mr. Kearns is my staff attorney. What a case did we find out that we could use to, at least for this particular purpose, so that Mr. Clyde has a basis for me to look at?
Yes, Judge. It's a 2005 case, Supreme Court Order, Morse Communications LLC versus Griffin, 279 Georgia 735. 737, since that's up there.
One more time. Did you get it, Mr. Clyde?
Yes, I did.
Okay.
And I'd be happy to respond to that. Your Honor, here's my concern about the Griffin case, is that is essentially a Rule 22 case. So it is essentially addressing when are the television cameras, when are the still cameras permitted in the courtroom. My understanding from what the court's articulating is not only would the cameras be turned off, the Rule 22 issue, but the media would be asked to exit the courtroom. And I assume by that, all other witnesses, all other non-attorneys or defendants would be asked to leave the courtroom. That's essentially closing the courtroom.
Yeah, for that, and as I mentioned, it's for a very limited time period. And I realize that, this is fairly, controlled. We usually don't close the courtroom for, it's presumed to be open, but I wanted to make sure that I at least gave you an opportunity to respond. Does the state wish to respond, or any of the defendants?
Your Honor, I don't. The state's not at this point. I was actually trying to look at the case law cited, but it's not state's motion. So unless I find something helpful to elucidate any issue, the state at this time does not have any additional information to share.
Okay. Anyone else from the defense?
Yes, Your Honor. Gracias, Menace.
Yes, Mr. Menendez.
Sorry, we would just object to that. I would.
Object to what, sir?
Closure, Your Honor, I would ask.
Okay. All right.
And so, Your Honor, I would alert you to another thing, just so the court's affirmed. At that point, when a defendant raises the objection, now there's a Sixth Amendment right that is triggered. And so closure of the court without a very detailed order creates a potential reversible penalty. And so it is closing the court in that environment. It is a undertaking that I think takes a lot of thought. So this is one where potentially having briefing on it may be worthwhile.
Guys, this is from court today. This is from the Rule 22 meeting. I'll show you some footage for with Doug in a minute. Do well.
Yes, Mr. Steele.
You might want to look at Alexander, ALEXANDER versus State. It's 313 Georgia 521 2022 case.
Alexander, you said is what is it?
313 Georgia 521. If there's an objection, Your Honor, to the presumption of structural error and prejudice under the Sixth Amendment. Otherwise, you have to show harm.
And what eventually happened, the judge basically said it was okay for the media to be in there. But he was trying to have the media not be in there during the time of yeah, this is from today, Eric. This is from this morning. The judge is looking at over some case laws and trying to make a decision of whether or not he's going to allow the media to be in the meeting. Thank you, Spitting Fire, for hitting the like button. Appreciate you. So people on IG, if you want to come over to Infamous Sylvia on YouTube, Infamous Sylvia on YouTube. I just came on here. It's not that many of you guys. You can just move over to YouTube. Because I'm going to show some more footage, okay? Oh, it's dragging, Eric. Jury selection is not going to end for about 2.5 to 4 months. Yeah, they're still doing jury selection. That lady came in, you know, the one that had to do the paper? He accepted it. This is what happened at court today. We had a meeting. We had a Route 22 meeting, and the judges trying to decide. Hey, Maria, they're trying to decide whether or not to let the media stay in for the some parts of the procedure he is having. Do you remember the Percocet incident? Well, they were going to have a meeting about certain things like that, and they didn't want the media in it because they had said it affected their Amendment 6, you know, to right to a fair trial. So they were trying to decide, you know, so, you know, because they let the video out about that whole situation, and it was video from the courtroom. The surveillance video, that is, from the courtroom. And the jurors that was here today, they all got excused. They all got excused. So on the 24th next week, they're going to bring another set of 300 jurors. Okay, guys, I've been covering the Young Thug trial. Those are on IG. I just wanted to share with you guys some of the occurrences. That's the judge talking to the in-house attorney. So eventually what's going to happen, he's going to okay that that the media be there. Because one of the defendants' attorney says they object to the closing of the courts to the media. So, and the state said that they did not the one who put the motion in. So I'm not too sure who put the motion. I don't know if it's the judge, but it wasn't well, I don't know. Well, the defense said they don't want the court closed. He said there was sensitive information that was going to be discussed. He didn't want to violate the Sixth Amendment of the defendants, which is Sixth Amendment is the Fair Trial Amendment. So he's talking to the staff attorney, the in-house attorney. The judge is talking to the in-house attorney. And they're going to make a decision. It's taking them a little minute. I might have to fast forward it. But this is my footage from the court. Those in the IG room, those who don't know, I've been going to the court every day since November to cover the case. This is the Young Thug YSL RICO case. And I'm doing it from YouTube, but I just have my phone to show the IG people that I'm here. Oh, thank you, Toria. Thank you so much. Well, IG people, I'm about to end this live. And if you want to come over to YouTube, come on over. Because only 2 of you guys in here. And I'm going to go to Facebook Live and see if I can bring some folks in from Facebook Live. All right, y'all. See you later on IG. Later.
Okay, Mr. Klein, I have looked at Alexander at 313 Georgia 521 and Page versus Lumpkin 249 Georgia 576. I'm not going to close at this point in time. I'm just gonna talk about some things that I need to talk about. So you and your colleagues will be able to report on whatever you see fit. Okay.
Thank you, Your Honor. I appreciate it.
All right.
And,
Okay.
and thank you again for your attention to these details.
Okay. All right. Thank you, sir.
Thank you.
So you heard him say, you can cover whatever you see fit, right?
Okay, Mr. Randolph,
Yes, Your Honor.
is juror 64 outside?
Yes, Your Honor.
All right, can we bring juror 64
Okay,
in,
now
please?
y'all remember who she is, right? Y'all remember who juror 64 is, right? She's the young lady who needed to write that paper. Hold on a second. I'm gonna
Juror 64, madam, can I get you to come to the podium, please, right here?
okay, so we're
Yeah, come
gonna
on up to the podium if you wouldn't mind. Hi, madam, how are you?
Okay,
You speak up just a little bit.
okay,
Okay, I had an opportunity to take a look at your paper that you submitted as in consideration to satisfy this contempt. Before I do that, is Mr. Thomas with you this morning?
no,
Okay, are you waiving his presence, or you don't need him? You didn't hire him for this particular proceeding?
I don't think so, no.
No?
No.
Okay, all right.
If I need it, just give him a call.
Okay, I just want to make sure. Okay. All right, madam. I find that your paper is sufficient and of scholarly worth. The first effort was, as we sent you an email to that effect. You corrected that, and I believe that it does satisfy the scholarly requirement. I got two questions for you. One of them is, what did you learn, or what was the most important thing you learned from writing this particular paper?
I guess it was just a reiteration of things I've learned throughout school. I hadn't had to revisit those amendments and Constitution in detail in a long time. So it's just reinforcement of education.
Okay.
I did learn some sections of Georgia in terms of some important cases that were tried here that I didn't realize were significant, that were done in Georgia, like
Such as?
Brown versus education.
Yes, ma'am. Okay. And then what else did you learn from this particular exercise that you want to share with us?
Nothing in particular, like I said, there's a lot of reinforcement of things.
Okay. All right. Madam, I'm not going to hold your time. I mean, I found it to be sufficient. I'm going to attach a copy of your paper to the order that I am going to, in fact, seal for the time being, because I believe it does have some things in there that I don't believe that should be disseminated at this point in time, given the fact we're still kind of selecting a jury. But I do find it to be, after the case is over with, you are certainly welcome to discuss it with anybody you see fit. Okay?
All right, thank you. I said, okay, thank you.
Okay, all right. So, don't want to see it on social media. Don't want to see it appended to any of the websites. Okay. You can release it after the trial is over and we have an appeal has been satisfied. Okay.
Yeah, I'm sure you know I won't do that.
Okay. Well, I just want to, because what it will do is just it potentially has the capability of influencing things that I don't wish it, that the court does not wish it to be heard of. It was for you and for your own edification in terms of satisfying the contempt. I believe it satisfies that contempt fully in terms of the scholarly nature of it and the things that I asked you to address, you addressed in a very artful way. So, but after this is done with it, you can certainly, this case is done, you can certainly comment to anybody you choose to at that point in time, okay?
Right.
All right. Unless there's anything else, madam, I'm going to go ahead and excuse you, okay?
Thank you.
All right, thank you, madam.
Okay, so you guys heard that the judge excused the juror who had to write the that paper. Remember the 30-page paper. So he excused her. He's satisfied. She's satisfied.
Here's that.
So,
Okay, Mr. Randolph, is juror 595 here?
Yes, Your Honor.
All right, juror 595, sir, come up to the podium, please.
all right, we're gonna go past this one. I just want you guys to hear that 64
Which
juror.
is what I told you not to do as well, remember?
Yes, Your Honor.
This juror is the one. Okay, let me tell you about this juror.
And I believe
This
that you
juror
were
is the
counsel.
juror that contacted one of the reporters while he's supposed to be in jury duty. And I mean on for him not to contact anybody. So he got in trouble. So he was held in contempt, and the judge was going to sentence him to 20 days in jail because he violated the order, right? So instead, the judge is giving him 10 hours, 10-hour community service, but he has to do it either in a school, a church, or I forgot the other organization. And then he has to come and be in the jury for 5 days as part of when the trial actually starts. He has to be there for 5 days, sitting in the courtroom. Yeah, so that's what's going to happen with this guy. So he got in trouble. That jury got in trouble. So he was held in contempt. So they take that very, very serious, y'all. If you ever have to do jury duty and you get stuck in a situation like that, don't do it. Don't do it, okay? Don't do it. Don't get yourself in trouble. Show up to jury duty. Because this is very important. There are people in this world who died for the opportunity to be able to be a juror. It's your duty as a citizen of the United States to participate in the judicial system, as a juror. Not everybody gets that opportunity, So if you get called on, do the job. Do the job, okay? So let me go ahead and fast forward it because he was going in on him. He went in on him. He was not playing with that guy.
We have hiccups in trials and we have to sometimes start over because people 5 days that you'll come for when we start this case, okay?
Yes.
Because maybe you'll see the importance of how this process is supposed to work. You're seeing it right now,
yes.
But everybody's got to do their part and everybody has to, follow the rules. And that's the only way we get a fair trial and a just trial is for both sides, okay?
Yes, Your Honor.
All right. Okay, all right. So, sir, if you'll step up here and see Mr. Kearns. Mr. Chamberlain?
Yes, sir.
Counsels, at this point in time, I'm going to have my litigation manager, Mr. Chamberlain, pass out thumb drives to all of you at this point. Madam.
With respect to the matter that the court will take up, I presume in a short while.
Just as soon as I finish doing these thumb drives, I'm gonna.
Will that not affect or impact the dissemination of the thumb drives? Ameliorating the need for?
No, I don't think so. I'm thinking about it. I mean, in terms of, I need to pass out the thumb drives, and that's a totally separate issue. So, all right, go ahead, sir.
Your Honor.
Yes, Mr. Chapman.
Jimenez.
Jimenez.
Jimenez, on behalf of Mr. Dorsey. I apologize, I waited till the juror was outside, required the court, it was proper for you to ask a question. I believe that he's aware of other jurors that have been following Mr. Pat and the media. And I don't know if we require them to tell us.
No, that would be improper for us to inquire about him. I'm going to excuse him because he violated my policy of the ad nauseum admonition. So this isn't a fishing expedition or witch hunt. I mean, I'm not gonna subject him to any future, examination in that respect. But that's your inquiry, sir?
We will ask when we ask the other jurors.
Sure. I mean, fair enough. I mean, yeah, I mean, that is certainly something that you certainly can ask it, depending upon what they tell you. Okay, all right. Anybody else? Okay, all right. Mr. Chamberlain, go ahead and as that's going around.
No, Toria, she didn't show up to jury duty. She was supposed to show up, but she went on vacation. Why does she have to write it? Because she didn't show up. And so the judge gave her, instead of giving her a sentence in jail, he gave her the opportunity to write an essay and write about the importance of jury duty and the history of jury duty. That's what she had to write. Okay, I'm gonna forward over a little bit so you guys could. And he's gonna give the schedule what the day is gonna be like for the next couple of weeks, the week's schedule. So they checking with the jump drive to make sure the list of the jurors' questionnaire. The questionnaire is inside the disk, the jump drive that they have. That's what he's doing now, is disseminating those the jump drive. To make sure that they work before they leave there. Do you guys want to see some other footage of the defendants? Let me know if you want to see those footage. So I was just showing you guys this part, and I'm about to end this. And let me know if you want to see other footage. Let me know if you want to see more. Yeah, okay. I'm gonna go to the front end and show you some of the footage that they have from the front end. Hey, Miss Deborah, how you doing? How are you, Miss Deborah? Deborah. Okay, I'm gonna bring up the other ones here so you guys can get a chance to look. Take a look. Alone. All right, here we go. Let me share it with you guys. Yes, all is blessed. All right, guys, here we go. I'm going to share it with you guys so you guys can take a look. Okay, I'm just going to tell y'all he's going to put his head down on the table again, okay? He is not sad. How can I get this thing off of here? Why is this thing still showing on here? What's this? Why is this still showing? Why is this thing showing? Okay, sorry. There we go. I took it off. He is going to put his head on the table like he always do. He's not defeated. It's just he put his head on the table. I don't know what this camera guy is doing. I don't know what he's doing. He got his stuff all up in the air. Hey, DJ Mason. It's afternoon. It's morning. You go, Young Thug, y'all. He's gonna put his head on the table again. And he is not defeated, y'all. He is just tired. So he's gonna put his head back up. This was today. He put his head on the table again. Man is tired, y'all. A man is very tired. He's not defeated. He's just tired. Hey, boss lady. See, he's tired. He's tired. See, he's tired. He's tired. This is from court this morning. Those that are on IG, this is court from this morning. Since everybody was in the court. This is footage from this morning's court session. This is February 13th footage. Well, it's February 14th. Happy Valentine's Day, everybody. It's Valentine's Day here. No, they haven't. No plea offer. DJ Amazing? Nope. I did that earlier today. I read, you have to go back to the live from earlier. This is Young Thug's trial. He's tired. No, he's just tired because he's not getting enough sleep. All right, I'm on my live on YouTube. This is the footage from this morning. But I'm about to end this. If you want to come over to YouTube, you can. It's Infamous Sylvia on YouTube. Okay, see you guys later on IG.
All rise. Superior Court of Fulton County Legislature is now in session. Honorable Chief Judge Judy Neville.
Hi, good morning, ladies and gentlemen. Please be seated.
Mm-hmm.
Mr. Randolph?
Good morning, Your Honor.
Good morning, sir.
Yes.
We have your 129 available this morning.
Yes, Your Honor, 149, 499.
Okay, and yours is 4.5 long.
I take number 64, supposed to arrive at 1:30 today, and 599.
Yeah, you're right, AR. This is draining.
Number
All
64.
right, I'm going to end this now. That's enough footage. That's enough footage. So in the morning, I will be up to do my affirmation, and then I will be showing you some paperwork in regard to YSL case. In the meantime, you ladies and gents, you have an awesome evening and happy Valentine's Day. All right, guys. Happy Valentine's Day. Happy Valentine's Day. All right, guys. Have a good night. Bye.